Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Saintier and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Welcome, dear listener. This is podcast number 26. For those of you who like counting, I'm reliably informed. And before we get going, great thanks need to be thrown out, as it were, to a new sponsor. How wonderful. We have a new sponsor. That means we must have at least one listener, I'm thinking. So...
Well, let's hope so. Who knows?
Very many thanks to the University of Reading in that sunny clime and the School of Law in particular. So a great thanks to them. They are our new sponsor. And I'm not alone.
Yes, thank you.
As ever, I am joined by the lovely Professor Saintier, if I've mangled her French name, and the equally lovely Associate Professor Dodsworth. I think I should... Yeah.
Congratulations, Tim.
Oh dear. Oh, we're not going to do... No, we're not going to
Yes, we are.
Oh, you too.
Well, I'm also elevated to the great heights now.
I was going to say, yes.
Not that high. I'm sort of Lieutenant Colonel now. Anyway, Associate Professor Hemsworth. But here we are, and we are going to discuss the case Houssein and London Credit Limited, and that got recently to the Court of Appeal. And yes,
but before, congratulations to you, Maggie.
Yes, very much. Big applause.
Let's pass over all of that. You can still just refer to me as Mom. That will do nicely. Anyway, Houssein and London Credit Limited got to the Court of Appeal, and this enables at least the lovely Séverine to discuss the penalty rule, which I think she's quite keen on. And some listener out there might remember the well-known Cavendish Square Holdings and MacDessie case, or the Parking Eye and Beavis case, which is equally entertaining, I think, but also important about the topic of penalty clauses. So as we go, we possibly have to unpack that, as our raison d'etre with these podcasts is to unpack contract law. But also as we go to try and explain this case and perhaps find any points of interest or maybe even disagreement. Who knows? I don't know. We travel
on this podcast.
Travel hopefully to arrive, maybe at the end, with some agreement. But anyway, in brief, this is a case about a loan to a company. So London Credit had provided a loan to a company of actually £1.8 million. Secured on assets, and that was to include the home of Mr. and Mrs. Houssein, and that explains the names of the parties. This facility was to run for a 12-month period, and the interest was 1% per month compounded, meaning after each month one has to recalculate, taking into account the interest which is accrued in the previous period of time. So it's going to roll up and roll up and roll up, as it were. The gross sum lent included rolled up interest of £75,000 and fees, which seemed quite high to me, but what would I know, of £225,000. London Credit took legal proceedings because of the default in payment of sums due. It also claimed breach of a provision as to non-occupancy of property. Part of the loan had been repaid, I think about 1.2 million, but 800,000 was still owing, and that included £180,000 in interest, and that continued to accrue at a daily rate of £2,500. I don't know about you, but that would bring tears to my eyes, that daily rate. Receivers had been appointed over the property, and at first instance, the judge had dismissed a number of defences. I think there was a scattergun approach, if I might put it thus, in terms of trying to fend off attack, because claims were made by by way of defence under the Consumer Credit Act, and also the Consumer Contracts Act, and undue influence, and all manner of things. All of those failed, basically, and so we are left on appeal with the key points of difficulty and dispute, and that is whether the interest charge on the default situation was recoverable. And there was also a construction point as to whether if the default rate interest was not recoverable, whether the lender, by virtue of the way in which the thing had been constructed, was entitled to charge and recover, if you like, the standard rate of interest before the default situation arose. So there's a construction point trying to get out, and there's also the other point about the general recoverability of the default rate interest. Now, the default rate interest was 3% above basic charge per month, compounded monthly. In other words, that is effectively 4% per month, compounded monthly, because it's 3% above the standard rate, and their standard rate was 1% monthly. So 3 over that, even my maths will get me to 4% per month, compounded monthly. Now, this is where it gets a bit interesting, I suppose, because I don't know about you guys, but I wondered what that equated to as an annual rate. And this is where my O-level maths, now that's an admission. That's an admission of two things, I think. To say that I've got O-level maths is an admission, firstly, of my great age, and secondly, as to the limitations of my mathematical ability. But anyway, I had to ask someone who is much more switched on about maths, and they seem to think that this is the equivalent of about 53% per annum interest.
Oh, wow.
And that, I think, is possibly where we are headed now, because the point on the recoverability or enforceability of this rate is about this idea of penalty. So I think Séverine will say much more about this, but just in basic intro to get us going, we have the Supreme Court decision in Cavendish Square Macdessie, or sometimes referred to as Parking Eye and Beavis, because those two cases went together, to the Supreme Court in 2015, that is recalibrating, if you like, or restating or reformulating. I don't know, we could play with the semantics, but is certainly talking about what the penalty rule is and whether it still holds good as far as English common law is concerned. Now, that second question is an easy one. Yes, it's still good for English law. In other words, the common law will, on occasion, strike down a clause which parties have agreed, notwithstanding the idea of freedom of contract. They will strike it down as unenforceable if it meets this test, which we have to use since 2015, as to a penalty. So for a penalty, we're really looking at something which is extortionate, extravagant, extreme, disproportionate, or I think all of those words have been used. We may argue whether they make any difference. Looking at the legitimate financial, business, commercial interests of, in this instance, the lender. And so that's quite a difficult thing to get your head around, I suppose. It's somewhat opaque, I would say. But anyway, that's the basic test, and we'll probably have to unpack that and explore that and disagree or agree as time goes on. But the essence of it is, this is the Court of Appeal that necessarily has to apply that test, because we've got the Supreme Court guidance. And because it's an appeal, the Court of Appeal is asked to decide whether the first instance judge got it right or wrong. And their end result here is that the first instance judge got it wrong. Maybe the end result is correct, but the way in which she arrived at the end result is not correct, in which case it's got to go back to another first instance judge to have a go at this, because a number of things come out of the test which apparently had not been properly applied. The first thing is this rule of penalty striking down only applies if what we're looking at is what's called a secondary obligation. that is an obligation which arises on breach. If it's part of the primary deal, primary obligation, then there is no room for the common law to strike down a clause. That's enshrined in this idea of freedom of contract. Now, there will be a different difficulty in many instances deciding whether something is a primary obligation or a secondary obligation, and that perhaps we'll unpack that in a few minutes. That's down to construction of the contract and a matter of substance rather than clever drafting. But in essence, that is the idea. And the Court of Appeal said it was perhaps implicit in the first instance judge's reasoning, but he didn't really articulate that clearly, so really that should have happened and didn't happen. So that's the first point. The second point, I think, where the main criticism lay of the first instance judge was that this test, this assessment, evaluation, call it what you will, has to be done objectively rather than subjectively. And I think that's possibly the main argument where the first instance judge went awry. He was looking at the subjective, that is the individual thought processes of London Credit itself, and that's not really what you're supposed to be doing. So the end result is this matter will have to go back to the High Court to have another go at it, as it were, but to apply the test that's come out of Cavendish Makdessi. First question is it a secondary obligation? If not, we can't even start looking at this idea of penalty. So that's the threshold test, if you like, or the first base position. And then the main guts of this assessment will have to be objectively, is there a legitimate business interest in an interest payable in a default situation at this particular rate? And because it's a lending situation, we've got lots of previous cases that talk about that, and it's going to be probably an uphill struggle, I think, for the borrowers here, because the rate, as I've calculated it, is something like 53% per annum. And the cases that we have where it's succeeded in that sort of context have been up really 400%, 300%. So we've got some perhaps way to go. And I suppose, I don't know what you think, Séverine, what you think, Tim, there is the difficulty in putting your finger on this idea of legitimate business interest and how that is actually done. And all the Supreme Court say it's impossible to give harder tests than that because it's going to depend greatly on the context. Can't have a test completely serviceable for all times, for all contexts. Can't have a test entirely formulated in the abstract. So there you are. I've spoken far too long. What do you think? What do you think about any of that?
Well, what I find interesting, the fact that there was also an interpretation, and so Maggie, you've laid clearly the fact that this was a huge deal, and the distinction between the interest rate and the default rate, and when one arises and when the other one comes in, and still the clause. So I don't know how many clauses there were in the contract, but we know there were at least 12 from, the fact that the interaction between default and standard rate was not clear, because the question was to know whether as you said, the standard rate could be claimed when the default rate was no longer.
Yes.
So if it was a penalty,
I think they've been very clear about that, though, haven't they? That the
I know, but therefore
standard rate does not come back in.
No.
Fails. No.
But for me, I find that quite interesting, because that could have easily been articulated in the contract, and it was not. So it just shows that it probably is very difficult to draft.
Wouldn't that be difficult to do, though? Because you would end up effectively saying, if our default rate is held to be unenforceable, then we revert to our standard rate. And that's kind of like almost
unlikely something that someone had in mind when they were drafting
Well, it's almost an
agreement, right?
invitation, isn't it? It's almost an invitation. It's raising doubts yourself as to the enforceability. So I'm not sure that is a very sensible way of going about things, but that's just my off the top of my head thought.
And for me, that just shows that, drafting a contract in a logical manner is not as easy as you might think. So that for me, that was an interesting
Well,
point.
if you're a lender, you're going to want to hide in the herd, if you see what I mean by that.
Yeah.
You will want a default rate which does not call attention to yourself. You want a rate that looks like the going market rate for this sort of lending situation, even though in a default situation, which is why I think that even the Court of Appeal is saying we don't have enough material to make the judgment ourselves as to whether this is a penalty or not.
I know, and that's why it's been referred back.
Yeah, so it's remitted back, and
Yes.
If it was 400%, then I think they would not have done that. Maybe, do you think? It would look more obviously disproportionate, if I use the word that Lord Neuberger used in Cavendish Macdessie, wholly disproportionate. But it becomes a sort of almost like a gut feel, which can't be right either, can it?
No.
But I think that's where that question comes in, and this to me that was the most interesting one. This idea of the legitimate interest, because here the judge is saying, well, it's a self-evident commercial reason, right? There's just a higher credit risk, and therefore that's that. Now that's not at all what the judge at first instance said, and I think that's really quite an interesting one, because if we look at Cavendish, there was basically we needed to make sure that deal goes through, right? That was so you're backing it up with a money. I'm not allowed to call it a penalty, am I? But a monetary incentive, let's say. And the same with the parking, right? You've got to keep the traffic flowing, and therefore you put a park. Here, we're trying to motivate the payment of money with the payment of money, which is a very interesting, right? We're wanting to make sure that people don't default.
Yes.
Because then they'll be at higher credit risk. But really, we're wanting people to pay money by making sure that they pay money.
Yes, but
so in comparison to the car park, where we were trying to get the traffic flow going through, and the specific performance element of Cavendish, right? We're wanting to protect the goodwill, there's something else here. Whereas here it seems, well, we're trying to protect ourselves against a higher credit risk, which is if somebody defaults, which somehow you would expect that is something they take into account when they calculate the rates. Now, of course, you've got a motivation, maybe the motivation is higher to not default on this particular loan. But there is a certain logical difficulty. I mean, I get it. I get what they're saying, but it's just not quite as simple, I think, as in the Cavendish or the parking eye type scenario.
I don't think you can distill out, as it were, the deterrence aspect from the loss aspect to the lender. These are inextricably intertwined, and I don't think it's possible to do that. The Supreme Court, didn't they say in Cavendish and Macdessie that deterrence doesn't make it a penalty? The fact that it's there to deter does not make it a penalty.
Exactly.
That's fine, but it's a question of the means by which you, and in fact Lord Sumption stresses that, doesn't he? It's the means by which you are doing this. And has it become extortionate, extravagant? And as Lord Toulson had said, these are very strong words and designed specifically to convey the idea how high this bar is set. And the deterrence is a feature of the lending, for sure. But there's also, rather like freeing up the car park, so as an extra charge if you overstay, which is the parking eye Beavis, if any listener remembers that one. That is a legitimate, as you say, commercial interest to keep the free movement of traffic, and they are parking for the amount of time that they have agreed to park. And that's separate from the deterrence aspect. But what I'm trying to say is that they're totally intertwined, and I don't think you can say what portion of the interest rate calculation has been earmarked or is capable of being earmarked objectively as deterrence, and what bit is to compensate for the fact that there is a greater losses once we're in a default situation. If we're a bank, we are faced with a customer that we're constantly having to chase and extract money out of, and we don't really know how much we're going to get out of them or how long it's going to take and what sort of arguments they're going to come up with. It becomes more difficult to manage. And this legitimate business interest is a difficult thing to nail down. And I think the Supreme Court is saying you probably can't nail it down precisely in a financial sense.
For me, I was going to come in on the deterrent, and at paragraph 34 by Lady Justice Asplin, to see a clause can still be penal even if it is commercially justified, but it cannot have as its main reason to be used as a deterrent. So the commercial justification for me has been introduced by the Supreme Court in the Cavendish one, and so now we have further distillation that it's a 3-part test. Does it come in as a secondary obligation for breach of a primary obligation? Then is there a commercial interest? And then finally you go into the whether it is extortionate, extravagant and unconscionable. So for me this is interesting. The commercial interest and the deterrent are indeed part and parcel of this assessment, which absolutely you're right to mention that it has to be done objectively, and the judge in the first instance didn't. So it is difficult, but for me that is the interesting part that shows where the court can use its, dare I say, discretion in looking at it on an objectively common sense.
They wouldn't like that word though, would they? This is not a discretionary exercise.
No, I mean that in the sense that because everything depends on the fact and that it has to be done objectively, for me the objective assessment allows the court to consider the context, and therefore that's where, yes, technically it's not a discretion, but that allows them to look at the context. And therefore, if I go back to your very useful mathematical example of the distinction that here, the default rate, even so, I hadn't quite appreciated it, but therefore 4%, in fact, on the calculation, it's 53%. That is indeed completely different from the 400% of the other case, which was relied upon, which I forgot, the Lord's Veil, which therefore allowed to say that it was not valid. So for me, that is the beauty of creating these tools by which judges can apply it in a contextual manner, and by contextual manner allow the judge is not discretion. I do appreciate this is the wrong
word.
I
suppose
would
we agree on evaluative judgment?
Evaluative judgment.
That's probably a better way of expressing it, isn't it? Because
yes,
you don't have a range of choices as a judge. That would be a discretion. This is a judgment call, as it were.
You've got parameters within which you can indeed evaluate.
But it's either it is a penalty or it isn't. It's black and white to that extent.
It is.
And using the guidelines so far as they are to come from Cavendish Magdesi.
Magdesi, yes, absolutely. I think it is also worth noting that this was a unanimous judgment in the sense that Lady Justice Asplin, gave the leading judgment, and Lord Justice Newey and Lord Justice Baker simply agreed, even though I don't like when the judgments are too long. Sometimes it's quite nice when.
Well, I suppose that they're only having to evaluate whether the first instance judge has apparently applied the test from Magdesi correctly.
I know. And it will be interesting to see.
And because they sort of swerved off, shied off having to do the judgment themselves as to whether it is a penalty. So maybe there is less to disagree about, if you see
True.
what I mean.
Yeah.
The thing I noticed, I don't know if you've noticed this phrase legitimate interest seems to be one that we find from time to time on what I would call sort of policing the outer limits of the contract law, common law, controlling the bargain which the parties have agreed. Because it's a phrase that I think was in White and Carter, you know, that much older case about holding a contract breaker to the bargain, and you continue to perform your side of the bargain, notwithstanding they have refused to do so. Do you remember that sort of idea about running up possibly what looks to be a wasteful activity because you are holding them to the bargain? And the House of Lords, it was then, because it's 1960 something, isn't it, said that this is possible if you don't need the contract breaker's cooperation in order to fulfill your part of the bargain. If you've got, or rather expressing it negatively, the law wouldn't allow you to do that if you had no legitimate commercial interest in doing so. So it's a phrase which is not new. We've had it a while back, and that's a sort of policing what I would call the outer limits of where the common law would say, hang on, chaps, that's not cricket, as it were. You should not be doing this under the guise of contractual rights. And it's also come in that Times Travel Pakistan Airways. Do you remember when we were looking at that one about economic duress? I think legitimate interest is a phrase that was sort of sprinkled in that. And the idea of unconscionability. Do you remember that equity word was used very pointedly in that setting? Was behaviour unconscionable? And we've got it really now again in the penalty idea, because that's some of the language which some of the judges, at least in Cavendish Makdessi, used, did they not? Maybe it depends on their background that they might resort to equity type language. But this extravagant...
I think in Makdessi, it did talk about unconscionability.
Paragraph 38, it comes up there that it's impossible to lay down abstract rules about what may or may not be extravagant or unconscionable. And I highlighted that in a similar way. It almost feels like we're getting the common law version of good faith, you know, that does all sorts of different things. That was the wrong two words to use here. But it's sort of Maggie's going to change her mind fundamentally.
Proverbial bull, isn't it, really?
No, I was on that. I was just going to say that the parallel. So Maggie, it's funny. I dared not raise the fact, you know, of the notion of legitimate interest, because I remember
you thought I'd have an aneurysm.
In a previous position where Tim and I were colleagues, I did raise it, and Tim said, yes, but it was in a different context. I thought, okay, I'd better not raise it. But the one thing, therefore, that Maggie, you were very brave in, indeed, they are in three different contexts. But what is interesting is, so Tim, you mentioned good faith. For me, this is the negator of good faith. It is what happens if there is bad faith in a way, or, you know, so, but yes, it is interesting that you have mentioned that. Maybe there is an article to write.
Well, if you
did I mention an article in the previous one? Now I think I see it, you know.
What they have in common, though, is I've described it as sort of the outer limits of where common law is prepared to intrude into the bargain. You know, that's a big deal, isn't it, for an English court? Because of freedom of contract, we really don't want to go down that road, and we'll only go down that road in extreme situations. Yes. And I think that's what's kind of similar. Although I accept entirely these are different contexts, what they have in common is that sort of extreme edges of activity in a contractual nature when one party is holding to their strict legal rights in the sense of what's written, as it were, in the contract. And it's at what point English common law will say, no, that's not acceptable.
Yes.
And that,
I agree.
That's very difficult to find that point for English law, isn't it?
Yes, I agree.
And what make that point.
Do they?
Sorry, what I tried.
Sorry.
Yeah, what I tried to articulate badly, and what you've said, the point that they all have got in common. So the problem with good faith is to define it, but what English law does in relation to good faith is that says this is bad faith. So that is what they have in common. At which point, in all of these circumstances, does it become so bad that you're not allowed to do it? So here, when it is extravagant, when it is extortionate, when it is unconscionable, in the context of the Pakistan airline, with the name escapes me, but it was duress, it was a legitimate act of duress.
Yes, it was lawful act.
Yeah, lawful act of duress.
duress.
At which point, so at which point does it become unlawful, etc., etc.
Yeah.
And then in the point of being able to effectively perform the contract, if the only reason is to claim damages, then that is not a legitimate interest. So it's yes.
So
I'll
Tim,
stop
you were going to say something.
Sorry,
I was going to say that the point that you make about how difficult it is for the court to interfere with freedom of contract, that point is made at paragraph 35, where they also pointed out the penalty rule is interference with freedom of contract, which, this is a key part, undermines the certainty that the parties are entitled to expect of the law. So we can see just how high the bar is in these instances. But around about the same time, actually, they're also discussing this idea that it didn't really matter that this default rate applied to all of the breaches. Now, that was something they discussed in Cavendish, and I was wondering what your take was on this. This default rule just applies in whatever breach basically occurs. Should that have been more at the forefront? I mean, I think it's probably not that important anymore now that we have the legitimate interest test, and it was much more prevalent beforehand when we were talking about the pre-estimate of loss. The days before.
Well,
Cavendish.
I suppose there are
but
there are still two forms in which this might arise, isn't there? Really, you might have a clause which describes itself as a liquidated damages clause, and which would be enforceable, but not if it's really in substance effectively a penalty. So for those sorts of clauses, which is not an issue in the Houssein London credit case, you would, I think, still look at the sort of balance of things as to the sort of things that you're talking about, really, I suppose. The sum stipulated, is it out of all proportion with the maximum amount of damages that would otherwise have been awarded or would have arisen as a matter of fact. And if you've got a balance or if you've got a collection, a basket of defaults, and they're all going to end up with the same amount of compensation under your drafted clause, that might be an indicative factor relevant to the judgment as to whether this is out of all proportion to the maximum sum that would be obtained. Because if you've got a breach that results in a very minor consequence financially, and yet you have the same very large figure, as it were, that might pertain to a much more serious breach, that might be an indication that what you've got here is effectively a penalty. But
because it's not a true estimate.
Yes, I think that strand of law is still good.
Still there.
Yeah, I think it is, but it tends to get sort of buried.
You'd say that is a separate strand, not just taken up within the fact that a liquidated damages clause, as we defined it there, is simply a legitimate interest. Right, the legitimate interest is we're pre-calculating the loss.
I think it was. I think
or
it was
would you
Lord.
say that's a separate strand? I mean, it's an
I think
interesting
it was
question,
Lord
genuine
Hodge,
interesting
but I'm
question.
going on my memory now that in Cavendish and Makdessi he makes that point that there is a separate sorts of clauses that is the argument, is this liquidated damages and therefore enforceable, or is this actually a penalty not enforceable? That wasn't an issue, I don't think, in Cavendish, and neither is it an issue in the case that we're talking about now. So it's not quite the same guidance, I suppose. So I've used it's a slightly different strand. I'm not saying that that's the phrase the judge would use, but it is slightly different when you've got that sort of clause, if that makes sense. It's much simpler, I think, what I'm trying to say there. And yet, you were going to say, and yet?
Sorry, I dare not.
Go on.
Because in a way it shows,
Go on.
my ignorance, because, I mean,
there's nothing wrong with showing ignorance, because we're all ignorant, and through ignorance comes understanding.
In a way, how the rules, because the Dunlop case, which was the main case on liquidated, was changed by Cavendish. So for me, Cavendish, when I explain it to my students, and therefore when I explain it to myself in order to explain it to the students, it is the new rules on liquidated damage clause. And that was one of the questions that was at the back of my mind when I was looking at this. Why have they not used the vocabulary liquidated damage clause? So from what you've said, it makes perfect sense.
Because I don't think the clause was of that nature.
Of that nature, I know. But therefore, that makes me, the penny drops, and therefore I'll have, my students this year will have a more.
I'm going on memory, but have a look. I think Lord Newburgh in Cavendish, didn't he say what was said in that old case Dunlop is fine. These are considerations. It's not a test per se.
I know it's not a statutory that was applied, in the past, almost as a statutory guidelines. And I know that was, but no, it's just for me again articulating what it is that we are talking about. And Cavendish for me in my head was always about liquidated damage clause, but in fact this case shows that it is much wider.
No, I don't think that would be an accurate label if you were really pedantic about matters, because that the parking I Beavis, I think that is more what you're talking about. But the Cavendish Macdessie clause was if the seller was in breach, he was defaulting, he wasn't going to get certain payments.
I know.
So he was losing payments.
He was losing payment,
and
there was a compulsory purchase at a particular rate.
There was an option to buy at a particular rate.
A compulsory.
Yes.
He didn't have any option.
No, the other side had the option. Yes. But you wouldn't call that a liquidated damages clause. A liquidated damages clause is merely saying if you're in breach, to avoid the wrangle and uncertainty of trying to nail down precisely pounds, shillings and pence what our damages would be, can we agree up front in the event of a breach situation, this is what the damages would be?
I know. So therefore, why can't we call this? And so, dear listeners, I am completely showing my ignorance here, and therefore that maybe I hadn't quite appreciated the impact of the cases. Why? Because here, the interest rate and the default rate do give a clear calculation of what is going to happen in the event of a breach. Why can't we call that a liquidated damage clause? Because it arises upon a breach. That is what I am arguing, and therefore maybe I am wrong in...
Because we can't call it a penalty clause.
I know. So for me, it's either a liquidated damage clause and it is valid, or it is a penalty and it is unenforceable. For me, that's the binary. So why can't we call this a liquidated damage clause, which in the decision they never do?
No,
have I been teaching it completely wrong?
I suppose you could.
It's much broader. What they're saying is it's much
siding here with Séverine.
Well, there are provisions that you wouldn't naturally think of as liquidated damages provisions. Nevertheless, they might have a penalty aspect about them. And that's what's happening in Houssein
I know.
and London Credit.
But
I mean, the argument you could make to try and back up Séverine's argument, just to add a little bit of fire to this, is that we could say, well, if it's a legitimate interest that's being protected, then it's kind of a liquidated damages clause in that it's paying for that legitimate interest. So we're just pre-estimating the loss that occurs from.
It sounds artificial to me to label.
No, it is not artificial.
Yeah, no,
it is not artificial. What my line of thinking follows, or is in the, so is it a valid liquidated damage clause? So following Cavendish, it is valid provided that there is a legitimate interest. This legitimate interest arises from whether it is classified as a secondary obligation arising from the breach of a primary obligation that has to be commercially justified, i.e. it can have a deterrent effect, but that cannot be the primary aim, and it cannot be. Then you go on to the next. If there is a legitimate interest, that liquidated damage clause can nevertheless be regarded as a penalty. And for me, the vocabulary is very clear in my head, but perhaps I was wrong, that therefore it becomes a penalty if it is extortionate, extravagant, etc., etc. So it is a liquidated damage clause if it's commercially justified and not extravagant. So for me, the vocabulary is, and I am raising it to make clear in my head whether therefore calling that Cavendish changes the rules on the acceptability of liquidated damage clause is the wrong way to do it, but I can't think of anything else to call it, because it's the word penalty means that whatever they had in a contract is not valid. By calling it a penalty, that makes it unenforceable.
Well.
And do you know?
Hang on. This is. Hang on. Just clear up this with.
Am I being pedantic? Am I seeing a problem where there is not?
I think you're putting too much weight on the labelling of things, and that we have to look at the substance of the thing rather than the label. And calling something a liquidated damages clause is merely shorthand, and there may be clauses that are much broader in the way in which they are crafted, but they still fall within the scrutiny necessary to decide whether it's unenforceable or not. So liquidated damages clauses would be a very common instance, maybe, but it sounds to my mind artificial to label an interest rate being charged by a lender when situations, so far as the borrower is concerned, are changing and they are falling behind in their payments, to suddenly reclassify that as a liquidated damages clause. It's semantic to my mind, because I don't think it takes you anywhere. You are still with the guidance that comes out of Cavendish and Makdessi. So I think it's academic, but I think it's too semantic and nothing really turns on it. But it doesn't sound accurate, realistic in this setting that we've got a lender with a bank.
Do you know who is not just academic,
Probably not,
but also practical? Well, that will be our new sponsor. The University of Reading School of Law has sponsored this podcast. Check out their M-Law program delivered in partnership with the University of Law. You'll get your LLB in Law Professional SQE1 and SQE2 preparation provision, preparing you to sit the solicitor's qualifying examinations, and you can even add a year abroad. Go to reading.ac.uk/law for more. A big thank you to the University of Reading and the School of Law for sponsoring Unpacking Contract Law. But back to the semantics.
Okay, Maggie, you and I had been in agreement for far too long, so
Now I agree with you on
It
that.
had to
Therefore-
change.
so-
No, it was just
so therefore, as lawyers, we like boxes. We like to explain things which fit into a box because X.
well, you might. I'm not sure I do. But
Oh,
There
wow.
comes
Gosh, we are
Hoffman.
disagreeing very well. This is beautiful. Yeah. So, what would you call Cavendish?
there you go. You see, you want a label.
Yes, because for me,
And
the distinction.
Why do you want?
So-
why do you need a label?
Because what is this clause? What is this problem we are discussing, if not a liquidated damage clause? What prevents us from saying that these kind of interest rates which come when they default? So it started more in my little head to try to understand why we have a new rule for, according to Cavendish, liquidated damage clause, and why is this. I do appreciate that this is not quite the same, but it's very similar. So semantically, why put them both in the
I mean,
same?
there's a point there.
package?
I mean, there is a point there. If we've got
Yes,
if we've got
Because
a
thank
legitimate
you,
Tim.
interest that we're protecting
Yeah.
the
Yeah.
financial, because that's all contract law can do, bar specific performance. We are,
Yes.
in money terms, protecting the legitimate interest, and since it's been pre-calculated, in a way, it's a pre-estimate. I mean, I suppose it's not a pre-estimate. It can't be extravagant,
No, Tim, go on.
but
Agree with me.
It's not a pre-estimate of loss at all in this sort of situation. It is simply saying, in a default situation, the loss to the bank and the risk of loss to the bank has changed by that fact, and therefore at that moment the rates
that sounds like a
changed.
pre-estimate.
No, but that's where
No, it's
No.
I don't think it is.
that is where Cavendish only. So that's where comparing Cavendish to the Dunlop case, and that the pre-estimation of the loss cannot be the main thing, but the legitimate interest, as long as it is not extravagant, extortionate. So the two are never. So it changes the manner in which the rule is assessed, but we still, as here, they still did talked about the pre-estimation. It cannot be. So for me, the two are still linked. So
Yes, I'm not arguing about that. It's just that you seem wedded to the idea of the label.
yes,
And it's only that label that you will countenance. And all I'm trying to say is there might be some contractual provisions that aren't accurately or strictly described as a liquidated damages clause. Nevertheless, they have about them sufficient to engage this common law rule about penalties, because they arise on a breach situation, and what they are stipulating for might be questioned on the basis of commercial legitimacy. So all I'm saying is it's broader in scope than the purest narrow forms of liquidated damages clauses. And I think the difficulty that perhaps we're having with this is in a lending banking situation, perhaps that is hard to see, really, that context maybe makes it harder. And in a sense, I don't know what you think about this, but I'm going to say I think maybe the point that you're really talking about is the difficulty that we have in identifying what is a primary obligation and what is a secondary obligation. Because if you look at the Cavendish-Makdessi case, there is some differences in view in the Supreme Court judges themselves. Their lordships weren't on all fours, as it were, on those clauses. Some in the Supreme Court thought a clause was a primary obligation, and some thought it was a secondary obligation. So I think that's telling us that's quite difficult sometimes. And it shouldn't be by clever drafting, and they're very clear about that. It's about substance rather than form. But to identify what was the primary deal and where that stops, as it were, is quite difficult sometimes, isn't it? Don't you think?
I thought it was a nice way of understanding why the payment arises. So that I never had any problem with, and in fact I thought that was quite neat to therefore link things back to obligations and therefore performance interest and etc., and therefore legitimate interest. But I can recall indeed that there was no agreement, or it was not always entirely clear in the Magdesi case what it was. So
to distinguish between the two, because one is that's just the price of what you're buying, and the other is a secondary obligation. But quite often they can be pretty intertwined, right? I mean, here we've got that kind of situation. Is the risk of default is also in some ways part of the price, and okay, it's a bit clearer here in the way that I think it was set out, both in the deal and with the default interest. But
no, you probably don't have an argument in this particular case, I think, because the rate was specifically to change on the occurrence of a default by the borrower. So it's not, for example, where situations change and it's nothing to do with default of the borrower, the circumstances change outside of the control of the parties. That would more clearly be a primary obligation.
Gosh, we disagree again.
Well, the risk to the lender may change because of factors nothing to do with the performance, compliance, non-default, call it what you will, of the borrower, and necessarily, therefore, the rate might need to be charged on a different basis.
I know.
That would be more obviously still a primary obligation. It's the fact here you've got default very clearly. The interest is very clearly tagged to this default situation. So I don't think you really had an argument possible in this case that it wasn't a secondary obligation. And I think the Court of Appeal just sort of said this is implicitly so.
I know. But therefore, again, I am maybe showing my ignorance or misunderstanding of the rules. But the reason why, for me, in my little head, I quite liked the primary secondary obligation as set up by Cavendish was because it was linked it to compensation and the aim of damages, because a liquidated damage clause or whatever we call it is damages.
Looking at a damage situation.
Yes. So what I liked about the Cavendish case and the distinction primary secondary obligation, it is because it was linking it back to the primary aim of financial compensation through damages. The case escapes me, but there is a famous quote that the primary obligation of the parties is to perform their obligation. Failing to do that, photo production and security call. Thank you.
Yeah.
So
Lord
Diplock
first coined this primary secondary, which I think he took from the French, Séverine. Does French law not have this?
French law is for equitable damages. Liquidate. The name is
but the phrase primary obligation is opposed to secondary obligation. I'm sure it's a French writer.
Maybe you're teaching me something here.
And Lord Diplock picked on this, and I think it comes from photo production security. So back to 1980.
Okay.
I don't know that we went further back than that, but anyway.
But therefore, what I really liked, because when I, both in teaching and research, I quite like to see, the the rhythm of contract law, for want of a better word. So for me, the primary secondary obligation was really neat in making sure that what we are talking about here with liquidated damage clause or any other wider as we are talking here is things that arise upon a breach. So for that
yes, but as Tim says, this is easy to say in the abstract, but often at the edges quite difficult to make the distinguishing features between those two. You know, you want neat, tidy boxes, you're saying, and therefore you want neat, tidy rules. Yes, in the abstract, it sounds pure, simple, neat, exactly what Séverine wants. But in reality, in application, maybe there will be some difficulties to act, and that, I think that's what our argument has been
probably
the last few minutes. Is really in this particular setting. Is this a primary obligation here? Is this a secondary obligation? And you were sort of coming at it in terms of labelling it as a liquidated damages clause.
Yeah, because I mean the easy part here is the primary obligation is to repay the loan, right? And then so
yes, but repay the loan with the interest that is accruing on that
So there could be
loan.
circumstances we could imagine where, for example, a third type of interest occurs, which is less linked to a default by one of the parties, or the. I mean, what we could see if they say actually,
if some event changes and it's not to do with default of one of the parties, you would not call that
or
a secondary
if they foresee
obligation.
certain circumstances in which they're trying to incorporate default as part of the deal. So options to default basically could be primary obligation. So if you've got to be careful here, because the court will say this is a matter of substance, not form. And if we look at the real nature of what you are drafting, and it by its nature it's really directed to the consequences of breach by one of the parties, then you can call it what the hell you like, but it's a secondary obligation. Like, I am genuinely making this up now, so this may not work. I'm just gonna go out with something, and we'll see if we can have some fun with it. So
good. I'm not the only one who's gone on a limb.
But if we took something, for example, that they foresee that if renovation work was going to be done and that might be delayed, and therefore there might be a default, that a different type of interest would apply. Couldn't that be?
Well, if you remove the idea, but you strip out this default business and simply say that if the deal is XYZ terms, on the assumption that development takes place within this window of time, that's what you're sort of saying. But in the event that the development is late, then these are the new terms.
Or that you cannot. I mean, we would be basically acknowledging that they can't repay it.
It would still be a default.
I mean, it wouldn't be a well. I mean,
it would still be a default because it couldn't be frustrating.
No, it wouldn't be. Yeah,
because it's foreseeable.
Well, no, but you'd have to look very carefully at the event. That's why I'm saying if we had circumstances changed which were out of the responsibility of the parties. Can you see we are outside the scope of default? We're not looking at default. We're simply looking at circumstances
that makes for an
changing.
Easier comparison. Yeah.
That's fine. Yes, that's fine to my mind, because that's still the primary
the
deal,
easy example for a primary deal. Yeah, the
varies through
primary
time.
example would be, and if a water leak occurs, you have to pay extra, right? That would still be primary. That's completely separating the two from any form of default, right? So that's not default. That's a circumstance happening.
What is it that you're both
so
trying
where
to get
would
at? I am a bit lost.
We were trying to run through scenarios, I think, in which we could imagine a an event happening that is clearly a primary obligation, but also a clause where it may get close to a secondary obligation. And I was trying to, that's what I wanted to do with the example of the building work.
But how can it be when the secondary obligation is the obligation to pay damages? That is the distinction between primary and secondary obligation. You do what the contract says. If you don't, you have an obligation to pay damages.
Well, the distinction is between the deal that you have agreed, the performance part, is a primary obligation.
Yes.
For a secondary obligation, you're looking at a breach by a party.
Yeah.
So if you don't have breach by a party,
Yes.
you're not talking about a secondary obligation.
No, I agree.
So I think Tim is trying to imagine circumstances that at first blush might look like a breach situation, but actually in terms of its substance is not.
You said
it's
it
still
so much
a
better.
primary
Maggie.
obligation. I think that's what you're saying.
But forgive me, what would be the point of this? Because at some point that primary obligation...
Point would be that if it's a primary obligation,
you wouldn't
remember freedom
be
of
able to even
contract,
check.
the court has no common law machinery that is not procedural, like undue influence and so forth, or misrepresentation of unpicking
We don't even get
that.
to the legitimate
That's the whole
interest
point
test.
of primary obligation. Because you remember, you recited it, Séverine. You said there's this threshold test of secondary obligation. In other words, there is no policing which the common law is able to do using this language of penalty, unless what we're talking about is a breach situation of one of the parties and a contractual provision which makes some provision, I've used the word again, some contractual clause which makes provision in that situation. Do you see? So if it's still part of the original bargain of performance and obligation and rights and so forth that the parties have cast and agreed themselves, you don't have any basis upon which to make an argument that this thing that I've agreed is a penalty.
It's fundamentally on consideration, right?
It only arises.
But that's not the primary obligation that is decided as to whether a penalty or not. It is the secondary obligation, not the primary.
Yes, no, quite. So you can't argue about penalties if what we're talking about is a primary obligation.
Okay, I must be dim because I don't see the point of why we're trying to define the primary obligation.
Because Tim has made the point that in some circumstances, the line between what is a primary obligation and what is a secondary obligation in terms of analysis may not be that easily done.
It
I think
was
that's
indeed.
the point you were making, wasn't it? Or tell me I've got that complete. And I was trying to offer to him, off the top of my head, an event that you have made provision for in the contract, which changes the nature of the bargain and the risk perhaps for one of the parties, and therefore the terms are going to change if that event arises.
Yeah.
So that's some contingency which you can foresee that might happen, and it makes it worse perhaps for one of the parties, and therefore they want more out of the deal if that event happens.
Okay, so if that event happens...
This event is nothing to do with breach by the other party. That is a primary obligation, and I don't think the common law can touch it, certainly not using the language of penalties and Cavendish and Macdessie. Because that's the bargain you've struck.
I know that the secondary obligation only arises. Okay.
So you need to be able to have a clause under your spotlight which in its substance is making provision for a breach situation by one of the parties. And I suppose that is in part why if you look at Cavendish and Macdessie, you will see that there's some disagreement between their lordships as to whether a particular clause is a primary obligation or a secondary obligation. It matters because of what they call this threshold test if it's not a secondary obligation, it's game over. We have no armory to attack it. You're on your own. You agreed it. Goodbye. Does that make sense?
I am lost.
That is probably because we're nearing probably the longest podcast
yes,
we've ever done.
I know. Yes.
So we may.
Okay. What you mean is, shut up, Maggie.
No. That's not what I mean. But yes, I think maybe this is a good
clearly
time.
It's taken us a long time after the summer break. It's taken a bit of a longer time for us to get into gear, get
back.
Again.
Yes.
But I think we'll have to probably draw a line there, and we'll thank our new sponsor.
Our poor listener is worn out.
And well,
thank you for bearing with us, dear listener.
Absolutely, and thank you for sponsoring us as well,
still
University
there.
of Reading School of Law. If you've got any suggestions, any ideas, any cases you want us to discuss, please send us an email at unpacking.contract.law@gmail.com. We'd love to hear from you. And I think we can say goodbye. Thank you very much.
Thank you indeed.
Thank you, and thank you, Reading.